I'm going to go ahead and introduce Jason. Jason is, I got to know Jason because of his wonderful mom, who is engaged in our Facebook discussions, and we wanted to discuss criminal justice reform, and she's like, I have got the person for you. And so not only her son is a professor at RIT, at Rochester Institute of Technology in this field, and he and I have had a really good time going back and forth and talking together. And then he was so gracious, he recruited some people, and I'll let you introduce them when they get here, from the community to give us their perspective. So I'll let him do that later, but we'll just let him get started. So he's going to kind of give you some content, just like Bruce did, and then they will join us later, and you'll have a chance to answer questions. So that was a different kind of discussion than this, and what I want you to hear here is the great need we have as the church to engage in this issue. We need to be involved on an active basis in what we can do to help bring change. So listen to what they have to say and go home and do something about it.
Thank you, Kathy. Is this mic on? Can you hear me? Perfect. When I agreed to do this, I didn't realize the panel that I would be following, but I'm really grateful, and it's refreshing that these important conversations are being had. So I commend this conference for doing this. Yesterday, I sat through the morning session, and I realized I had some things in common. First with Suji, who mentioned her travel to Canada. I too traveled from Canada. Circumstances certainly different, but my parents brought me to Canada, not from South Korea, but from Wilmore, Kentucky, where I was born, when my father was in seminary at Asbury, and also share some things in common with Dan Sheffield when he talked about growing up in Northern Ontario. I too spent formative childhood years in Sault Ste. Marie, in a wonderfully and culturally diverse congregation there that my father pastored. So some similarities there. As Kathy alluded to, we're going to have a panel discussion, but I wanted to set the stage by highlighting some challenges within the criminal justice system and some injustices within the criminal justice system that hopefully will lead into a good conversation about reform opportunities. To get us started, I wanted to highlight that Ben & Jerry's ice cream has created a new flavor devoted to justice reform. It is Justice Remixed. I've searched for this at my local Wegmans and I didn't find it, and I panicked and thought, well, if Wegmans doesn't have it, maybe this really isn't out there. But I trust it is. It features cinnamon and chocolate ice cream with gobs of cinnamon bun dough, and spicy fudge brownies. That sounds terrible, doesn't it? So if you need an excuse to buy ice cream, I can recommend Justice Remixed. A portion of the proceeds go to support local grassroots reform initiatives. And Ben & Jerry's have done a good job of highlighting some of the challenges with justice reform. I just finished a book, and this is a book I would recommend. It is a book entitled Rethinking Incarceration. And in this book, Dominic Dubois-Gilliard highlights the need to examine systemic injustices within the justice system and calls us to understand the biblical mandate to address those challenges. So this afternoon, I want to focus on three examples or three forms of injustice within the justice system, each related to the key component parts: police, courts, and corrections. I want to focus on the systematic use of police stop, question, and frisk as a policing example, focus on wrongful convictions as a court example, and then mass incarceration as an institutional corrections example. So first, the practice of stop, question, and frisk has sort of become popularized due to its initiation within the New York City Police Department, beginning in early 2000. Police have always engaged in stepping out and questioning individuals when they have reasonable suspicion that a crime has occurred or is about to occur. What happened in New York City, however, was a policy initiative that attached a quota expectation to this form of behavior that resulted in over 5 million of these street interrogations between 2002 and modern day. I've listed a quote there by David Weisberg, who's a professor at George Mason University, and he uses the analogy of radiation or chemotherapy to treat the common cold. And it's a useful analogy when you look at the volume of these stops. So this is what that looks like. In a minute, we're going to look at some data from the New York Civil Liberties Union that focuses on that year 2011, when officers in New York City, and this isn't just unreported, these are documented by a UF-250, it's a standard form completed by police officers in New York City, when they step out, question an individual, and frequently engage in a frisk or a search of that person. 700,000 in the year 2011. Courts intervened after 2011, looked at the patterns, looked at the documented, substantiated, or unsubstantiated reasonable suspicion connected to these, and you can see the precipitous drop. I'm not convinced that in 2017 there were only 11,000 of those. I think there's probably more of that activity going on today that's simply not documented by these forms anymore, but nonetheless, you can see that incredible pattern. Related to the race of individuals caught up in this, these are data again from 2011, that peak year. Half of those involve citizens that were black, and almost a third citizens that were Latino. Proponents of this practice say, well, the police are just going to where they know crime is happening, they're seeing things that are legitimately suspicious, and therefore this is just a natural pattern. However, people that have studied this and that have controlled for crime rates in those communities, controlled for race-specific arrest rates, controlled for race-specific victimization rates, and applied that, say that doesn't help explain. When you control for all of those things, you can't take away the fact that this represents systematic and systemic racism. Another clear piece of evidence pointing towards this is examining the nature of those stops in precincts with especially low rates of black and Hispanic populations. So these are the stops in the 10 lowest black and Latino precincts in New York City. So if you look at the top, in the 17th precinct, the census population indicates that there are fewer than 8% of the population that are black and Latino, and yet 71% of the stops involved individuals in those communities that were black and Latino. And you can see the clear pattern. The shocking statistic is the one at the bottom. Well, it's all shocking, but the one that stands out is the one at the bottom. So in that year, in 2011, police stopped more young black men than existed in the city of New York. What that means is that beyond just stopping every single one, and it wasn't every single young black male that was stopped, it means that there were individuals that were stopped not once, and not twice, and not 4 times, but 12 times. One of the justifications for these stops is something that the police call furtive movements. Does anyone know what a furtive movement is? So you're walking down the street and you see a police officer and you cross the street or you duck into an alley. Well, if this pattern has been established and you fall into that category and you've already been stopped 6 times in the past 6 months, you might cross the street or duck into an alley. It creates this vicious cycle where the pattern of racial disparity and discrimination is used to justify the stop, and it continues in this negative feedback loop. I'm not sure if this is really clear, but some of these stops are based on the justification that it is successfully getting firearms off of the street. So you can see, I'm not sure if it's visible, but in 2003, there were only 160,000 of these stops, and the police recovered 604 firearms in that year. And then you can see this rapid increase until we get to the peak year in 2011, where there are almost 700,000 stops. However, the success rate at finding firearms doesn't really increase substantially due to the increased volume of those stops. Criminologists that have studied this and that are interested in understanding the success have looked at those stops in which there was a frisk or a search of the individual, and whether or not the individual that was interrogated on the street was arrested, whether or not a gun was found, whether or not drugs were found, whether or not there was a warrant. And this is a fairly consistent pattern, whether we look at New York City or Baltimore or Philadelphia. The success rate or the hit rate of these stops is about 10%. So it means that if police engage in 100 of these activities, their false positive rate is about 90%. Their success rate is 10%. When we look at the race-specific hit rates, this is where it really provides evidence of continued racial discrimination. The police are more successful at finding a warrant, a gun, drugs in the stops that they do of white citizens compared to black or Latinx citizens. Another way of saying that is that the reasonable suspicion bar for stopping a white citizen is substantially higher than the reasonable suspicion bar for stops of black and Latino citizens. So that disparity in the success is additional evidence, not just the quantity, but the success of those stops. So why does this matter? In this book, Rethinking Incarceration, Mr. Gilliard says, within many impoverished communities of color, police are perceived and experienced as an alien, occupying force. This intensifies with each unsubstantiated stop and frisk, which means 90% of them or more. Every text scandal, every unarmed citizen killed, whether one affirms this perception of police or not. This is related yesterday when I heard Kathy say, if someone tells you they're offended, believe them. If someone tells you that they have a problem with this activity, believe them. And if you don't, look at the proof. I don't want to say the devil's in the details. Maybe the proof is in the pudding. Is that a better term? The proof is in the pudding when we look at the evidence and when we look at the data. Moving on to a court outcome, we can examine wrongful convictions and exonerations. This is data and information taken from the National Registry of Exonerations. I would encourage you, if you're interested in this, to take a look at their website. They have data on exonerations that have occurred since 1989 up until, I pulled this last night, 9/12, and there have been almost 2,500 in that period. And you can see how that has changed and increased over time. Some of those exonerations are based on DNA evidence that completely excludes the individual that was convicted. Other times, there's other evidence that contributes to those exonerations that may not involve DNA evidence, but nonetheless point to the actual innocence of those individuals. On average, the amount of time individuals spend incarcerated, typically in state prisons, who are eventually exonerated, is about 10 years. And it changes depending on the type of offense, but it's a substantial amount of time across these cases. And when you add it all up, it is thousands and thousands of years that have been lost. There's some common causes for these wrongful convictions. Mistaken witness ID is a substantial contributor to wrongful convictions. And this is a psychological finding. People overestimate their ability to remember details. That becomes really problematic under stressful circumstances, like a personal victimization. And police practice in this area is also problematic. So when a description is given out and the police are told to look for someone matching this description, a young black male, 6 feet tall, wearing a hoodie. And the police find that person and they stop them and they hold them there, and then they wait for the other officers to pull up and have a victim stand across the way and say, "Is this the person?" And they say, "Yeah, that's the one." Well, that's a major contributor to this problem. Perjury or false accusations often involve co-defendants, so co-arrestees, sometimes jailhouse informants that are providing evidence or information that lead to evidence that leads to a wrongful conviction. False confessions are another one. Many people say, well, why would anyone confess? I would never confess. I would never admit to something that I didn't do. Well, probably most of you have not been subjected to a police interrogation. Sat in a room, and not a big room like this, a small room, we'll call it a closet, that has 2 chairs, and you sit across from a trained investigator who's been trained in psychological techniques to get people to say things that they want them to say, and hour after hour after hour, until finally the harm that was caused is minimized, they're provided an out, and they're provided a statement. And the person finally says, fine, just let me sign, I have to get out of here. It's a fairly common contributor to wrongful convictions. False or misleading forensic evidence is another one. Within recent years, there are a number of forensic science experts and techniques that have been completely debunked. The lead content analysis technique, where they're trying to connect ballistics and the lead content of ballistics, complete garbage. Bite mark evidence, nonsense. Microscopic hair fiber comparison, proven to be unreliable. And yet this is the type of evidence that is being used to convict individuals. The first picture is sort of a sad but telling example of a bad lineup. And we laugh, but this is sort of what happens. Peeps versus chicks. Or an investigator that is on the other side of the glass that knows the identity of the suspect, instead of using a double-blind eyewitness approach in which the investigator and the victim don't know the identity of the person that's been arrested. The bottom bottom two tables examine this impact of false confession. And the relationship between false confession, mental disability, intellectual disability, low IQ, and the tendency and the ability to get confessions, along with age. And when those two things are combined, false confessions happen at a fairly high rate. A good example of that is the case of Lucretia Murray. This individual, this girl, was 11 years old. This is a case, I believe, dating to the early 1990s. She was at home. An individual brought a toddler that was brought into her care, and shortly after this 2-year-old was dropped off in the care of this 11-year-old child, the toddler was unresponsive. They rushed this 2-year-old to the hospital, and she died. And the medical doctors said, these injuries happened fairly recently. They point the finger at this 11-year-old girl. She's taken into police custody, separated from her grandparents for 3 or 4 days, and then she's interrogated by the police, absent parents, grandparents, and a lawyer. For hours upon hours, she denies, I don't know what happened, I wasn't responsible. They eventually write up this statement. She doesn't even know the meaning of homicide, let alone negligent homicide. She signs the confession. The evidence in her defense is presented that these injuries had existed for a long period of time. They weren't immediate, and yet, at trial, this 11-year-old child was convicted of negligent homicide and sentenced to 25 years in prison. She served 3 or 4 of those years before being exonerated. An extreme example, but an example that demonstrates these patterns of injustice that we have within our system. Mass incarceration. Yesterday, Junia talked about this period from 1980 to present day. And you can see it in the explosive rate of incarceration that we have in this country. The bottom line are federal prisons, so our federal prison population. Then we have local jails in the middle, and then the top line is our state prison population. This is a rate, so these are rates per 100,000. I guess the good news, for years and years, they just kept going up and up and up, and everyone watched it like, how can this continue to go up? Crime is going down, and yet our incarceration rate just keeps skyrocketing. It has finally stabilized. It is finally decreasing, but you can see this explosive growth. What this means is that the United States has an incarceration rate of about 700 per 100,000. It's a point of comparison. The incarceration rate in Canada is about 100 per 100,000. Australia, New Zealand, the United Kingdom, 150 to 200 depending on the country. The United States far outpaces the rest of the world, and that's just the average across the states. There are other states whose individual state-level incarceration rate is over 1,000. Oklahoma, Louisiana, Texas, for example. This breaks that down by the different correctional institutions. The largest contributor are state prisons, holding about 1.3 million individuals currently. It's probably difficult to see, but it also breaks it down by offense category. One thing I would just highlight, here are drug offenses here at the state level. Other drugs are drug possession with intent to sell versus 45,000 which are just strictly drug possession. I point that out because a common movement within the Justice Reform Initiative is, well, if we could just release all of the nonviolent drug possession cases from prison, that would significantly improve our mass incarceration problem. Well, this suggests that if we did that, at least at the state level in state prisons, we would be touching 45,000 out of 1.3 million. So I just point this out to suggest that unless we deal with all of these other contributing factors, simply focusing on drug possession at the state prison level is going to have a limited effect. We'll look at local jails in a little bit more detail, but importantly, not convicted are individuals that have been arrested, they're awaiting trial, they are innocent under the eyes of the law, but they are being held pre-trial in our local county jails. And then finally, federal prisons, a much smaller contributor. So as this suggests, 3/4 of our local jail population are there not because they've been convicted and sentenced to local jail, they're there awaiting the disposition of their case. So currently, and these are details from the Prison Policy Initiative, about 460,000 individuals at any given day that are confined in local jail just waiting for their case to be disposed of. How do those individuals leave county jail? Bail, maybe. Eventually, some of them. Any others? Sorry? Okay, some of them after a conviction, they might be moved to state prison. Plea bargain is a big one, right? Very few of those are leaving after having a trial. A very small percentage, especially among misdemeanors, are disposed of by trial. So it means that they are sitting there in much the same way that someone might be sitting in a police interrogation room and feeling, I want to get out of here, I want to get out of here, I want to get out of here. What might motivate that is a plea bargain. Certainly a lot of people are plea bargaining because it's in their best interest, because they've actually engaged in criminal conduct. But the question is, what percentage of those individuals accept a plea bargain that may have not been responsible for the actual accused act? So this shows this comparison between individuals held in local jail among those that have been sentenced to local jail because of a conviction for a misdemeanor versus those that are being held pre-trial. And you can see that a major contributor to our growth of our local jail population is this pre-trial detention population. In 1996, the individuals in jail post-conviction and individuals in jail pre-trial were about the same. Since 1996, the individuals awaiting trial in jail have increased substantially. Someone mentioned being released on bail. The median bail amount in this graph was based on a study in 2009 that estimated that the average or the median bail amount was $10,000. Among those that are held and detained in local jail awaiting trial, the median income of those individuals was $15,000. Among those men that were released, the median income was about $40,000. You can see the connection between income and ability to post that cash bail and your ability to be released pre-trial. The same pattern also exists for women on the right-hand side. So these are the number of individuals 1 out of 5 incarcerated that are incarcerated in being housed for a drug offense. Greater numbers in state prisons, just because of the size and the contribution of those prisons. A larger percentage of federal inmates are incarcerated for a drug offense. Where you really see it is when you look at the actual arrests. So the top portion of the bar represents arrests for possession. The bottom portion of the bar represents those arrests for sale or manufacture. The increase in those possession arrests also correspond to the increase in the pretrial jail detainees that we just looked at. So from 1996, right there, and then you can see a corresponding increase. So in understanding the growth of our jail population pre-trial, some of that is due to these drug possession arrests and the volume of those. Another common reform idea that is often thrown out there is that private prisons are a major problem. And I'm really concerned about a corporation profiting off of holding people in cages. However, what really drives our prison population is the public, state-run prisons. Private prisons represent a small fraction of that, and I think have their own issues, but we cannot deal with mass incarceration without acknowledging the role that our public prisons play in that equation. When talking about mass incarceration, a lot of people focus on the front end. The arrest, the conviction, the sentences, the amount of time, mandatory minimums that all contribute to the length of time and the size and the growth of our prison population. However, another very important contributor is what you might consider the back-end return mechanism. People that spend time in prison, some of them expire their entire sentence, they're released to parole supervision, and then either because of a new offense, but as this points out, often because of a technical violation of that supervision, they are violated and they're sent back. It varies from state to state, but there are some states where the technical violation readmission rate is as high as 30% or 40% of all new admissions. It means that almost half as many people are going to prison, not because they've committed a new offense, but because they've tested positive for drugs while on parole, they failed to abide by a curfew, so some of those technical conditions. One of the reasons for that is that parole is completely overwhelmed. With that growth and that explosive growth in prisons, beginning in the 1980s, we had, by the late 90s, by 2000, we had in communities like LA County, 40,000 individuals returning to LA every single year from state prison. Chicago, 25,000 people returning to Chicago. What do those individuals all have in common? They're looking for housing, they're looking for employment, they're fighting some of the problems and the relationships that they had that were the problem in the first place. And if parole is overwhelmed, and parole is looking for an efficient way to monitor this population, one very efficient way is drug testing. What are the triggers that are going to say this person is in need of greater supervision and perhaps in need of returning? So a zero-tolerance parole policy contributing to this back-end readmission rate is another very important problem and contributing factor. A couple of resources that I want to leave with you before we take a quick break. I mentioned Rethinking Incarceration. There is a corresponding curriculum that is available. It is connected to the book and the chapters of the book. You can find this if you search for Walking Toward Love. And again, this is connected to the book Rethinking Incarceration. There is a video series that is broken up into some of the issues related to criminal justice reform. I would recommend that you take a look at that and consider whether or not that is something that would be valuable for your congregations, for small groups or community group discussion points. The other one that I just recently have found, this is probably not very clear, but this is a curriculum that Prison Fellowship has put out. It is entitled Outrageous Justice. It is also a book series. You can download the digital book, and then there are corresponding chapters and videos. I would say Prison Fellowship, if 5 years ago, if you had asked me, is Prison Fellowship doing work in this area? I think Prison Fellowship has done a lot of work doing important ministry in prisons and chaplaincy and in that area. I haven't really seen them step back and look at some of these bigger systemic problems. My quick scanning of this curriculum suggests that they have, and they're moving in that direction, and that's something that I find promising. So that's another one that I would recommend that people take a look at. We're going to have a time to sort of reconfigure and get set for a panel discussion. But I thought in doing that, and as we transition, it might be helpful for you to talk amongst yourselves, turn to a neighbor, and discuss a question, an issue, a concern that you have related to the problem of injustice within the criminal justice system, or a reform idea or something that you've considered or find some value in. So take some time, maybe 5 minutes. We'll reconfigure the stage for our panel, and then we'll spend some time discussing criminal justice reform moving forward.